During the process, how many times will I have to go to court, go to meetings with trustees, those kinds of things? Is it something that I have to do, or is that something that you can do for me?
No, you never go to court. I mean, that's one of the misconceptions. There are some rare instances you would, but 99% of the cases never are in a court. You never see a judge. Everyone, though, has to go to the creditor meeting, and that is where you sit down with the trustee, they look over the petition. Now, the focus is different depending on which bankruptcy you're in. If you're in a Chapter 7 bankruptcy, the trustee is looking at, one, do you qualify? Are you under the income limitations for the family size? Like I mentioned earlier, single person Colorado, $45,000. Family of 4 in Colorado, $78,000. The bigger your family, the higher it goes up. So first they're looking for that, are you eligible for the bankruptcy? And the other thing at the creditor meeting, mainly they're looking to see, do you have something that's non-exempt that they can take to pay creditors with? That is really their focus with it. And in most cases, it's the tax refund. If you have a tax refund coming that you have not received, the trustee has the right to take that and then repay it to creditors. In a Chapter 13, the focus is different. They're not looking to take things from you. What they're looking to see is, do you have a compliant plan? Did you give us all the information that we need to make sure that you can actually afford the planned payment, or that you're eligible for a Chapter 13? And so the focus is completely different. But with both of them, they call it the Meeting of Creditors. And the reason why is that your creditors have the right to appear to the meeting. And sometimes that really freaks people out, because the last thing they want is Chase Bank in there saying, how can you do this to me? Why, you ran up the card and now you're filing bankruptcy.
It sounds like a scary meeting.
It does, but the reality is 1 out of 100 cases has a creditor show up. Credit card companies do not show up to the Meeting of Creditors. Mortgage companies, car lenders do not show up. Really, the only people who ever show up is if you had a business and you're discharging, another business. Ex-spouses tend to show up, and they can make it kind of entertaining in there. But we usually know. I usually have a good idea when I look at their list of creditors, and I could say, yeah, from what you told me about this person, don't be surprised if they're at the meeting. And only the thing they can do at the meeting is ask questions with it. And again, it depends on the tenant. If you're in a Chapter 7 meeting, they're asking questions, but they have to keep in mind the trustee's only concerned about is whether or not my client hid an asset from them. And as long as you've disclosed everything on your petition with your assets and your debts, regardless of who shows up, you have nothing to worry about.
A couple of kind of specific things, I think. If a husband and wife are in a situation that the bankruptcy looks like it should be done, do both spouses declare bankruptcy, or can it just be one or the other? And what's the impact on the spouse who doesn't file?
One can file without the other. A lot of people think, well, if I'm married, my spouse has to file. And at that first meeting, what we do is, if there's one spouse who's reluctant to file, what we do is we break apart their debts. I do have a lot of clients who come in where they keep their debts separate from each other. And it's not uncommon where one spouse has all the debt in their name. They have the mortgage in their name, they have the cars in their name, they have all the credit card debt. And in that situation, that spouse can file. Other times we'll have the situation where one spouse has the mortgages and the car payments, and they want to keep those. But then the other spouse has all the credit card debt that's bringing them down. And what we do in that situation is, the one with the credit card debt, we file on them. And that way the spouse who has the mortgages and cars that they want to keep anyway, they don't have to be affected by it. The only impact that it has on the non-filing spouse, which is what we call them, is that their income counts towards whether they qualify or not. So if you're a married couple and one wants to file, we have to take into consideration both people's incomes as to whether or not that spouse is eligible for a Chapter 7. And that's it. We don't list the spouse's name, we don't put their social security number in, we don't list the employer. They're anonymous through the whole petition. And if they have a joint debt like a mortgage, the worst possible thing that can happen is that the creditor, the mortgage company, puts a note on their credit report that the co-debtor filed Chapter 7 bankruptcy. But the non-filing spouse does not see their credit score drop dramatically or any change at all. All it is just a no. And it can be done.
What if I have a small business that is, again, just a very small business I'm the proprietor of, I might have a partner or two in, and I'm looking at bankruptcy? What happens with my business?
Most of the time, nothing. What we do with your business is we look at what's the value of your assets in that business. In Colorado, you get a $20,000 tools of the trade exemption. And what that means is if the value of the stuff that you use to run your business is less than $20,000, the trustee cannot touch it at all. And again, it's liquidation, fire sale prices is how that comes up with. Most of the time, people in small businesses can keep their business, they can keep running their business, whether they're doing a Chapter 7 or a Chapter 13. And that's a common misconception out there, is the small business person always thinks, oh, I'm going to have to shut down my business because I'm filing bankruptcy. Not at all. I mean, if that's your income source, bankruptcy doesn't punish you because you're a small business owner or you work for a company. Mainly what they're looking at is, do you have assets that are beyond the exemption that they can take to pay creditors? And most of my clients fall under that $20,000 exemption, and so they're able to get out of that debt, keep their business going, and a lot of them see their business flourish afterwards because now their outlook's different. You know, when they're running the business and they have that huge debt load, the only thing they can think of is, how am I going to make that next payment? That's where their focus is. Once the debt's gone, they can start using their creativity and their talents to do the thing that they're best at. A lot of them see their business grow very well, and they do fine just right after the bankruptcy. So that's what the fresh start's all about.